Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, we are talking about marriage petitions and some of the issues regarding marriage petitions. Now, you have to keep in mind that anytime you walk in the door at immigration, they think you're lying. Okay, that's the reality. That's why they came out with the law giving a conditional green card for those who are filing marriage petitions, so that 2 years down the line you would have to file another petition to remove the conditional residency to prove that the marriage was real. So I have to let you know that there are clients who actually come into my office, tell me that the marriage is going to be fake, and what do they have to do in order to make it happen? And of course I tell them that's illegal, and I also tell them that to try to do a fake marriage in order to get the green card actually will take a lot more time and create much more of a headache than either doing the employment-based route or actually waiting until you fall in love with a real U.S. citizen or lawful permanent resident, as it may be. Now, when someone commits marriage fraud or doesn't have a bona fide marriage, and what I mean by bona fide marriage is for immigration purposes, it's not real. It wasn't entered into because of love. It doesn't mean that the marriage itself is not legitimate, because you go to Las Vegas and 15 minutes later you could be legitimately married. So what happens if they rule is that it's marriage fraud is you are denied immigration benefits for the rest of your life. And even if, 10 years down the line, you fall madly in love with a U.S. citizen and have 22 children born here, doesn't matter. It'll always be denied. You'll most likely be put in deportation proceedings. And then even if that doesn't happen, I've had cases where, there was apparent marriage fraud, and then 10 years down the line, the person who was paid says, look, I have a little favor to ask. I need more money. And by the way, if you don't give it, I'm going to notify immigration. So, it's a never-ending process. It's not worth it. I can just urge you not to do it. You may be able to say, well, I know four of my friends who did this, and they're perfectly okay. Well, maybe they are today, but what's going to happen next year, or the year after, or the year after? There's no statute of limitations for immigration to revoke the green card and put someone in deportation proceedings if they ever find out it was marriage fraud. And you never know what people are going to do. So given that, when you get married, the issue then is, what do you do? Okay, do you do an adjustment of status in the U.S.? Do you do a consulate processing outside the country? Well, if you happen to be in the U.S. and you happen to be here legally, then you can do an adjustment of status. However, if you are here illegally, then there is an issue as to whether you qualify for adjustment of status. For example, if you entered the country legally but went out of status, then you will not be able to essentially do what you need to do unless you can prove that you entered legally. This is a nice little exception in immigration law. Basically, the way it works is that if you enter the country legally and you have proof that you entered legally, then the fact is that you're going to be marrying a U.S. citizen is given such high priority that they allow you to adjust. Now, there are a couple exceptions to that. If you entered as a seaman and jumped ship, they essentially, the law doesn't want to encourage that, so it makes it so you cannot adjust status in that case. So then a lot of questions are, well, what happens if you entered illegally and you got married and want to adjust status? Well, generally the answer is no, you can't do it. But if you're under a law, what's called 245I, then you are able to adjust. So then the question is, how do you get under 245I? Well, the way that that works is if you had an employment-based petition or family-based petition or special immigrant petition, one of them, filed prior to April 30th of 2001, and you were physically present here on December 20th of 2000, then you're able to adjust here in the U.S. by paying a $1,000 penalty and then, the normal filing fees. Also, if it was filed prior to January 14th, 98, then you don't even have to have been physically present in the U.S. And you can adjust. And there's also various issues where, if your parent, sibling, other relatives were under 245I or filed the appropriate petition, you might be a derivative beneficiary, allowing you to go under it as well. Now, if not, then you just consulate process through your home country, where you might need a waiver. And I've got lots of other videos on waivers, so we'll leave that for now. Now, for the marriage petition itself, there's certain things that will flag immigration, basically to show that it's not bona fide or that more proof needs to be given. Like, for example, the husband is much older than the wife, generally, or vice versa. I can tell you that I had one in the past where there was a 60-year difference. That's 6-0. And sure, they asked. Sure, it was an issue, but we ultimately got it approved. Basically, the more of an issue it is, the more evidence you need. Okay, also an issue will be if you're not living together. If you're living in California and your spouse is living in Boston, you better be prepared to explain why. Most of the time, it's due to job location, things like that. But you have to be prepared to explain it. Also, if there's nothing jointly in both of your names, that raises a red flag. So you do have time. You're going to file the marriage petition in the first place, but you don't have to include all the incorporating evidence of the bona fide marriage at the initial interview. That's all going to come, at the initial filing. That's going to come at the interview stage. So, basically it's 6 months to a year after you file to get the interview. So what I always tell my clients to do is the moment after it's filed, and before if they can, but especially after it's filed, start getting everything jointly together. Get joint credit cards, get the spouse as a beneficiary in the life insurance policy, get health insurance cards, start getting both names on the rental agreement or the mortgage, whatever it is, and get especially the bank accounts. And don't do what some people do. Don't get a joint bank account, put $50 in there, and then never touch the account again. That's not what they're looking for. They're looking for evidence that it was properly entered into for the purposes of love, and not for the purposes of the green card. That's basically what it is. Now, one cautionary word is, a lot of people want to get married right away, and they're outside, one person's outside the country and the other person's in, so they think, well, hey, I'll come in on a visitor visa or a visa waiver, then I'll turn right around and get married. That's fraud, okay, because a visitor visa, you're supposed to come in and, go visit Disneyland, go visit your friends, do what you need to do in that regard, not get married. So if you're in that situation, take the longer but safer route of doing a fiancé visa, or the U.S. citizen, go over to the country of your fiancé and get married over there and do a K3. So those are the various options. Now, once you have the interview, sometimes they will put one person in one room, one person in another room, and they'll ask all kinds of questions, kind of like what you probably saw in the Green Card movie. And sometimes all the time people are nervous, and sometimes the officers are rude and, looking for the wrong answer and so forth. And so if, it happens that you go to the interview and, Joe said that you use a blue toothbrush and you said you use a red toothbrush, that's not the end of the world. it is possible to send in a supplemental declaration to clarify the confusion or the issues afterwards, in order to make sure, as best as you can, that it does get approved. Okay, now assuming that at the date of the interview you've been married less than 2 years, again you'll get a conditional green card, and then you'll be able to file to remove that condition at some point in the future, which is usually 90 days to 1 day before the expiration of the 2-year anniversary. Um, Now, when one is filing for the marriage petition, it can either be a lawful permanent resident or a U.S. citizen. Now, the exception I gave you above, where if you entered the country legally, you can adjust status, well, it has to be marriage to a U.S. citizen. But if you married a lawful permanent resident, you'll still fall under the exception once the resident applies for citizenship. So, usually in those cases, I'll ask the resident, go, how long have you been a resident? Make sure they qualify for citizenship, and then get them to be a U.S. citizen, and then file for the adjustment. But in any rate, the lawful permanent resident can still file the I-130 or beginning petition for the spouse, and if they don't become a citizen and they're outside the country, at least the visa number gets set, and at least the priority date, will eventually become current. Okay, so those are the basics on marriage petitions. More in the coming videos.